Ms. Eakes, I understand you have an issue you want to raise outside the presence of the jury.
I did, Your Honor. I just wanted to raise a couple of issues about defense counsel Mr. Oster's closing argument yesterday. And I did raise an objection at the time to one of these issues, and the court overruled it, but I want to express on the record what my concern is. Counsel got up, and I have a copy of his closing, and told the jurors that our own state's expert, Mr. Hallamore, couldn't hear with his own critical listening skills that there were statements that we said were on the videos, which is the "I can't breathe" statements. And he specifically pointed to the time when there's the dispatch and it says slow income, and there's it's Exhibit 659 is the actual recording. Defense counsel knows, and he said it several different times, that the state's expert actually did hear those things and did include it in the transcript. And it was not, and so it's not factually accurate. I think it's unethical to make an argument like that and say that the state's expert didn't find that, when in fact they know that the state's expert did, and that the only reason the transcript was changed is because of motions that the defense raised and the court's determination that it wasn't strong enough, heard more clearly enough, I guess, in order to eliminate it from it. So, it's one, and I think that that's an improper argument. What I'd ask the court to do is that I think the remedy is that the court instruct the jurors that 18A wasn't admitted, that it was an illustrative exhibit, and that it's not any parties or witness or expert witnesses transcript. It was a listening aid that was put together from multiple sources or something to that effect. To just, because again, it's one thing to say, hey, here it is, but to get up and say their own expert with his extra critical listening skills couldn't hear it, when in fact he did say that he heard it, and I think you can hear it very clearly on 659. So that's my first issue.
Well, I know what the response is going to be, and I think the critical listening skills was dripping with sarcasm as he said it. But go ahead, tell us what your response to that is.
I take complete exception to unethical argument. That's what the evidence is. I get to argue from the evidence, right? The court found 18A to be accurate based on the totality of the circumstances, to include the email between Mr. Hallamore and Mr. Liu, in which Mr. Hallamore says, I don't hear it. But if there's a consensus by the Attorney General's office, I'll include it in there. So if the court wants me to say that, I'll say that. But what I said is what the evidence is in the case, and that's proper.
Well, Your Honor, none of that was in front of the jury.
No, but to suggest that it's unethical is disingenuous, I think.
Well, I would disagree. I mean, he knows that the expert heard that. He knows.
No. I mean, that's just the point. We don't know that the expert heard that.
Well, that's not true with respect to 659. With respect to the dispatch. Okay, I mean, the email that he's referencing doesn't relate to that particular passage. And the court took out the second passage that's on dispatch because of the back.
Well, anyway, I hear your argument. I'm not changing a right ruling about it. It's a matter of, as we all have agreed, what the evidence is the recording itself. And the jury can either agree with you and hear it, or they may not hear it, or they may say it's ambiguous and they can't make it out. I don't know. Anyway, you had another issue?
Yeah, the second issue is that there's no missing witness instruction in this case, as the court knows. And again, I think defense counsel is implying that the state didn't call certain witnesses because they didn't support the case. And that's an improper argument where there hasn't been a request for, nor would there be a proper basis for a missing witness instruction. These witnesses are not uniquely available to the state. Court's not made any sort of finding about that. And to suggest that the state didn't call certain witnesses because they wouldn't support the state's case is improper under the case law. So I'm raising that for the court. It's already been said. I didn't object at the time because, again, the state's in a position of having to kind of highlight issues like that with their, but counsel knows that that's not a proper argument. And I would just ask that for future, because it looks like defense counsel for Defendant Rankin is going to make similar arguments, and of course Mr. Oster may get up and continue to make that same argument, and I think it's improper under the missing witness instruction rules.
Okay. Anything else?
Nope.
Okay, you have a response to that?
If I ask for that, I can argue that you can infer this and this is what it means. I can say the state didn't call witnesses who were present. They can ask themselves why the state didn't call those. That's proper argument.
Mr. Conrad?
After believe there was even testimony from their use of force expert who said that there were no other officers that had seen anything excessive take place that were on the scene. But I intend simply saying that there are 13 other eyewitnesses in this case, and the state did not call them because they don't favor their case.
Well, Your Honor, I think it's different to say, counsel's saying now that all he said was they didn't call him, but that's not actually true. What he said was that we didn't call them because they don't fit with the theory of our case and they don't support the state's case. And that's the difference. If Mr. Conrad wants to get up and say, hey, there are other witnesses and the state didn't call them, that's one thing. But to suggest that they wouldn't have supported the state's case, that's the improper part of the argument that the state's concerned about.
Well, it was a little bit of a mixed claim, but I agree with you. They did say that. But I say it's mixed in part because there was a claim as well that we claimed some of the witnesses that we called some of the witnesses that the state might well have called and didn't. I think I had didn't I at least ask you briefly about whether or not there was going to be some kind of argument about missing witnesses? There may have been a motion to limine about it. I don't remember. I'm usually not real sympathetic to the idea of missing witnesses, in part for the reason Ms. Eakes pointed out, which is anybody can call a witness. They're not uniquely available to one side or the other. We do sometimes see the argument of a missing witness when in the unusual case, somebody is sort of uniquely available to one side or the other. Let me see if I can actually find some law about this. I don't know if you actually have a cite to anything in particular. But since you didn't object in the first place, what are you asking me to do now?
I'm alerting the court that I would ask the court to instruct the defense that they can't argue that those witnesses wouldn't have supported the state's case or that they would have given testimony that was adverse to the state's case or imply anything along those lines.
One thing I want to point out as well is, the court's instructions right now places the burden on the state, and that reasonable doubt can be present from the evidence or the lack of evidence in this case. And so, the state had the option, it's their case, they had the option of calling in these officers that they interviewed every single one of them. We're certainly entitled to argue that it is based on those facts.
Well, on this, as you see, I'm just looking at some authority on this. I've got the case of State versus Montgomery, 163 Washington 2nd, 577, a 2008 case, which talks about missing witness doctrine. And it talks about it, though, in the circumstance of the defense and the state suggesting something. So they suggest that this is a particular problem with when the state does it against the defense, because criminal defendants have no burden to present evidence. And it's error for the state to suggest otherwise. But it does say, however, under the missing witness doctrine, the defendant's theory of the case is subject to the same scrutiny as the state's. The state may point out the absence of a natural witness, quote unquote, when it appears reasonable that the witness is under the defendant's control or peculiarly available to the defendant, and the defendant would not have failed to produce the witness unless the testimony were unfavorable. State may then argue, and the jury may infer, that the absent witness's testimony would have been unfavorable to the defendant, et cetera, et cetera. And then goes into some of the facts of that case. And it says, we have previously found that limitations on the missing witness doctrine are particularly important when, as here, the doctrine is applied against a criminal defendant. First, the doctrine applies only if the potential testimony is material and not cumulative. There's an argument that it would be cumulative here, maybe not. Second, the doctrine applies only if the missing witness is particularly under the control of the defendant, rather than being equally available to both parties. Third, the doctrine applies only if the witness's absence is not satisfactorily explained. For example, if the witness is not competent, or if testimony would incriminate the witness, the absence is explained, and nor instruction or argument is permitted. Finally, the doctrine may not be applied if it would infringe on a criminal defendant's right to silence or shift the burden of proof. Now, this is sort of the other side of that, but the defense pointed it out. It suggests here that claiming there's a missing witness can be appropriate in some circumstances. So it's never completely inappropriate, but certain circumstances need to exist. I don't know if there's anything peculiarly available about these witnesses to the state. Of course, there wasn't any explanation why any of these folks weren't called. Like, as I say, like somebody had died or something would explain why they're not being called. We have nothing about that. So it's kind of marginal, it seems to me, here, as to whether it's improper or not. Under all the circumstances of the case, I'll permit it. So, motion denied.
And then, Your Honor, my understanding is that we just received a moment ago a new slide deck from Defense Counsel Conrad. So that is completely different than what we've been looking at the last few days. So we're going to need a little bit of time to look at it. It's quite lengthy, as the court can see.
Okay. How much longer are you going to be? Well, I'm not going to limit you. You can take whatever time you want, but I'm just thinking I do need, it does, how much time do you need for this? Who's giving the rebuttal?
I am.
Well, then, let me ask this. I mean, if, well, have you looked at any of it so far?
No, I just started to try to look at it, but I haven't had a chance. I was listening to what the court was saying.
All right. Well, why don't we try to get at least started, and we'll see how far we get. And once we get to the end of Mr. Osser's closing, maybe take an extended break at that point, so you have a chance to look at that. Okay? All right, let's have the drink. You're closing when you're ready.
Thank you, Judge. We left off yesterday, I was talking about the process through which you should evaluate the case based on the instructions the court...
Because of coughing, the process.
Oh, that you should evaluate the case based on the instructions and the law that the court gave you.
And we left off with the three key witnesses that the state essentially is asking you to rely upon to find guilt in this case and how they're not credible. And that's a reason to doubt. Let's talk about the next reason to doubt. In this case, you know that there are 4 separate law enforcement agencies who are present and on the scene for an extended period of time before Mr. Ellis dies. Right? We have Tacoma Police Department. You saw 898, Exhibit 898, which lists the arrival of several of these officers based on the CAD report. There's over a dozen officers there at some point. But it's not just TPD, right? We know that 2 superior officers from Pierce County Sheriff's Department are on the scene within seconds. Officers Gary Sanders and Tony Messenio. They're on scene within seconds of Officer Rankin and Officer Ford. In fact, the evidence is that Gary Sanders is participating in restraining Mr. Ellis because he's not under control at the time. That means another agency, not just these officers, believed that was necessary to restrain him. Undisputed fact. We also know that Officer Bucat from the Lakewood Police Department is there within a minute of this, is on scene observing what these officers are doing with Mr. Ellis. Now, be clear, by the time they get there, my client's no longer even in contact with Mr. Ellis, right? Because we know once the hobbles are applied, Officer Collins and Burbank are relieved. And so Officer Bucat from Lakewood, along with Messenio and Sanders from County, are present, observing, and not intervening. We know Casey Jones from the Washington State Patrol shows up about 2 minutes later. And what do we know? We asked the experts, state's experts about this. Casey Jones observes Mr. Ellis actively resisting, smashing his head into the concrete. That's 4 agencies, all separate from each other, who are observing the conduct and not intervening. And ask yourselves why they're not intervening. Because the use of force is reasonable to address Mr. Ellis's conduct as it's happening. The state suggests through count 2, and now a lesser included of count 2, that somehow my client was negligent or reckless when he disregarded a substantial risk of death. That's the definition. In his acts. Not acts that occurred after he's gone, because we know he can't be an accomplice to acts after he's off, because the only person, according to the judge, that he can be an accomplice to is Officer Burbank, who's no longer there as well. Let me ask you this. How in the world do 4 separate agencies observe conduct that is a gross deviation from what's accepted and a substantial disregard for a substantial risk of death? It wasn't. That's why they didn't intervene, and that's why they did nothing except restrain him until him being Mr. Ellis until medical aid arrives. That disproves there's any sort of negligence or reckless, and what it certainly does is show no act of my client resulted in death. What else do we know? Well, we know there were dozens of officers on scene. Dozens of officers who were eyewitnesses to the conduct that occurred. The state didn't call a single one of them. Why? Nothing they would say is consistent with their story. In fact, all the experts relied upon their statements, and you didn't hear any information from any of these officers that suggested for 1 second that Officer Collins, Officer Burbank did anything inappropriate. Even more, once Mr. Ellis is restrained in 4-point restraints, not a single officer thought it was excessive force, or that Officer Rankin or Ford or Sanders or Lim, anybody else, Madden, who touched and restrained Mr. Ellis, did so inappropriately. Those are the facts. The state suggests that there was some duty of care that my client violated that somehow makes him criminally liable. Well, I'm going to ask you, look at your instruction packet. Do you see any instruction from the court that says any duty of care makes this criminal? No, because it doesn't. You have to commit an unlawful act and cause the death. The duty of care is just a way to try to get you guys to go around what the instructions are. Every officer on scene, according to that theory, had a duty of care. Every single one. Does it make it criminal? Maybe civil liability. This isn't a civil trial. Not a single instruction says that creates criminal liability, because it doesn't. Other reasons to doubt. How about this? I'm going to submit to you, Ayanna Malang or Miss White eviscerates the state's theory of the case. Because recall, their theory of the case is that these 3 eyewitnesses saw the entire thing. And they saw that these officers attack Mr. Ellis. I didn't hear any explanation in closing arguments to address how that could possibly be true, giving Ayanna Malang's testimony. What do I mean by that? Well, you recall Ayanna Malang lives a few hundred feet from the location where this occurs. She's laying down to go to sleep with her fiancé, now husband. She described this neighborhood as not unusual for her to hear interaction between folks and police, given the high crime in that area. So she's laying down. I think her words were, "I was almost nodded off to sleep, and I heard a commotion outside." Because I hear commotion outside regularly, didn't really cause much of a concern. So I laid there for between 30 and 60 seconds. Those are the facts. When it didn't cease after the 30 to 60 seconds, I sat up in my bed and I looked out the window. I looked out the window for 45 to 60 seconds. Right? So now we're at 1 minute and 15 to 2 minutes. And I see a struggle. And where did I see the struggle? I saw the struggle at the driver's side front headlight of the vehicle. Why is that significant? Because that's completely inconsistent with what Mr. Cowden said he saw, what Miss McDowell said she saw, and what Mr. Lowry said he saw. Because if it happened that way, they couldn't have seen it from where they're situated because they're obstructed by the police vehicle. But more importantly, they couldn't have seen the beginning of the altercation as they described, because we know relative to that 1 minute and 15 seconds to 2 minutes when Miss McDowell started recording, which she said was immediate because she started screaming. And Miss Malang said she didn't start screaming until after I tried to wake up my husband after that 1.5 to 2 minutes. So we know the struggle's going on for 1.5 or 1 minute and 15 seconds to 2 minutes before Miss McDowell even knows anything's happening. Because Miss Malang says, I try to wake up my husband and I hear her screaming. And I go to the window and I see her screaming, turning around, yelling at Mr. Lowry like we know, which is documented on the Vivint video. She could not have seen the beginning of the altercation. Mr. Lowry also couldn't, but Cowden as well. How do we know Miss Malang is 100% accurate in that timeline? Well, you have the Vivint video, 5:46. It's the first recording on there. When I played it for you yesterday, you could hear the struggle going before the video starts, consistent with what Ms. Malang says. It's also consistent with Matthew Collins' testimony that we're at the stoplight clearing the previous stop while we're sitting at the red light, and he told you why, that's our policy to avoid being sitting ducks at the location, as Officer Burbank is entering it. And you have the CAD report, it's Exhibit 17. And it says, and actually Mr. Fredericks confirms this, there's 1 minute and 12 seconds between the entry on the CAD report and the starting of the Vivint video. That just happens to align perfectly with Ms. Malang's timeline, confirming Officer Collins and Burbank's account as to how this started. Those are the facts. That's the truth of what the evidence is in this case. If that's true, we know the state's theory doesn't hold water. McDowell, Lowry, and Cowden didn't see what they said they saw. And what Officers Burbank and Collins said is 100% accurate. And if that's accurate, it's lawful, and we're done. State didn't even account for Ms. Malang in closing. Why not? There's nothing to rebut it. She's the only one of those 3 witnesses that didn't have contact with James Bible. She's the only one that still has her cell phone, so we can see what the communication was, and it didn't magically combust. Dr. Clark. We could talk about Dr. Clark for a day. But I'm going to submit to you Dr. Clark actually exonerates my client and the other 2 defendants. Why is Dr. Clark a reason to doubt? Now recall, he did the autopsy. He is the only expert that viewed the body to determine manner and cause of death. What did he say in his autopsy report? This is exhibit number 2649. This is page 2. The front is a cover page, and this is the opinion section right before he signs it on 19 May 2020. Autopsy examination does not reveal an anatomic cause of death. Why is that significant? Because that's called a heart attack, folks. Right? No anatomic cause of death if he died the way that Dr. Stankus suggested and Lieutenant Wilson confirms. What else does he say? The methamphetamine concentration is well within the fatal range and could have caused the death independently. State's own expert. Right? That's called reasonable doubt, right? If you can't tell us how he died, how can they claim they proved beyond reasonable doubt my client's acts caused the death? That's a fact. However, if it had, one might expect it would cause cardiac dysrhythmia, such as ventricular fibrillation, and would produce sudden death. Well, I'm going to suggest that actually what happened, right? He didn't have the life pack at the time, right? You would expect some dysrhythmia. Well, Dr. Stankus, we're going to talk about in a second, showed you the dysrhythmia. Whether it was ventricular or tachycardia or some other, it's there. Yet, in this case, upon arrival, the first responders, the decedent was close to respiratory arrest, but still had a sinus cardiac rhythm. Except he didn't, right? Remember, Dr. Clark's opinion was predicated on pulseless electrical activity and normal sinus rhythm, which didn't exist. He was wrong. He acknowledged that. Those things that I predicated my findings on were actually inaccurate. Those are facts. That's the truth. What else? Thus, it is likely, look at the words he's using, right? Likely, could, would. I'll explain why that's significant in a second. It is likely that the progressive hypoxia as a result of physical restraint, positioning, and the placement of a mask over the mouth is a significant factor and possibly the most important factor. The spit hood, right? What do we know about the spit hood? It wasn't applied by anybody who's before you. Whoever applied it is not an accomplice to anybody who's sitting before you. And if that caused the death, then our clients are not responsible. My client is not responsible because he didn't cause the death and he's not an accomplice to Officer Farinas who applied the spit hood. But there's more. Death, therefore, is certified as being due to hypoxia as a result of physical restraint with contributing conditions of methamphetamine intoxication and a dilated heart. Well, let's be very clear about what certification of the death as a homicide means in that context as opposed to this context. Because in that context, Dr. Clark told you it is very different than criminal liability. All he's saying is more likely than not, death is not of natural causes, therefore it's a homicide. I have to statutorily classify it as that. What that doesn't mean is it's criminal. I mean, I think he was very clear. We're going to talk about that in a second, about that not meaning this is a crime. But what he does say is contributing conditions of methamphetamine intoxication and dilated heart. Right? Now let's talk about, in a second, the significance of those, because those are what we call intervening causes of death. Instruction 25 tells you if Mr. Ellis did something intervening and not apparent to the officers, then that can be a cause of death. And even if you thought my client caused the death, which he didn't, would make him not responsible. So why is that significant? We'll get there in a second. But even the state's own expert is saying, I can't even rule out those things. In fact, what he says in the next sentence is, it is unlikely that this death would have occurred due to physical restraint alone. There's a comma. I'm going to get there in a second. But that's what Officer Collins' conduct is the physical restraint alone. The arrest and physical restraint. So Dr. Clark's telling you, in his autopsy report, Officer Collins committed no crime. Without the contributing conditions. The contributing conditions being the methamphetamine intoxication and dilated heart. Furthermore, he goes on. An argument could be made that the extremely high methamphetamine concentration should be considered the primary factor. And we know that to be true. Mr. Ellis had 2,400 nanograms of methamphetamine in his system. A lethal dose of meth with a dilated heart, and he died as a result. State's own expert. What else do we know about Dr. Clark? We know Dr. Clark, when he made this opinion, was not provided the life pack information associated with Mr. Ellis's death, monitoring what his heart was actually doing, showing both tachycardia, right, and normal sinus rhythm, which undermines that the death was due to physical restraint and he died of hypoxia. Because Mr. Liu didn't decide to give it to him.
I'm sorry?
Because Mr. Liu decided not to give it to him. Why? We know Dr. Clark was a consultant. They hired him as a consultant. They interviewed him separately, and then he participated in interviews of fire personnel, including Lieutenant Wilson. They didn't provide their own consultant with the life pack information before doing interviews about what the circumstances were surrounding the death. Ask yourself, why not? Because they know it doesn't support pulseless electrical activity or normal sinus rhythm. How is that possible? How did we get this far into this case when the state had the information that undermined their own experts? That's not all with Dr. Clark. What else did Dr. Clark say? Well, he told you, I can only really opine to 51% for purposes of my classification. In fact, there's a number of contributing factors that led to Mr. Ellis's death, and I can't even assign proportionality of those other factors to what caused the death. I'm going to submit to you 51% and an inability to even decide which of the 51% is related to which act is called reasonable doubt. Because the state has to prove that Officer Collins' act caused the death. Right? That's the law. We're not even close. What else do we know about Dr. Clark? Well, as Mr. Fricke said in his closing remarks, I pointed out on cross-examination of Dr. Clark that he prepared a PowerPoint presentation to present to the authority making a charging decision that said several things that give you concern, should give you concern, about his opinion and the validity of it. One, there's value in classifying this as a homicide to avoid the appearance of a cover-up. Remember when I asked him about that? He got angry at me, right? I disagree with that. I disagree with that. That's from the American Medical Examiners Association. Okay, well then why'd you include that in the PowerPoint that you were presenting to the prosecuting authority before making this decision? What else did he say in that PowerPoint? Other experts will disagree about the cause of death. Right? That's what he said. And that's what you saw here. Not only did Dr. Clark present that PowerPoint presentation to the prosecuting authority, he participated in an interview before he was retained as an expert. And remember, I asked him about that interview because we had the memo that documented what he said to the prosecutors before they decided to charge this case. And what did he say? While I can establish 51% for purposes of this, you're not going to be able to establish beyond a reasonable doubt. State's own expert told them that in December before they charged this case. Yet they charged the case. That's not all. Dr. Clark is then retained as a consultant. And you had me read and had him agree to substance of his consultation report to John Hillman, the chief of the criminal division of the Attorney General's office. What did that report include? That report included information that the state he thought should be aware of before making the charging decision, that the scientific and medical literature does not support hypoxia due to physical restraint. In fact, he cited 2 studies, which I read to him, and he agreed with. And what did those studies say? There's no statistical significance to the application of weight on the back of an individual who is in 4-point restraints. We did a study with 0 weight applied, 50 pounds applied, and 100 pounds applied. No statistical significance to respiratory effect or cardiovascular effect. And he agreed with that. Well, that's the state's whole theory of the case, that their own expert just said is maybe not even a thing. In fact, I had him read in there that positional restraint or asphyxia is not a thing. That's in the study, and he agreed. That was in the information I gave to Mr. Hillman before making a charging decision. Yet we charged this case. What else do we know about Dr. Clark? Dr. Clark got particularly aggravated at me when I suggested that his classification wasn't based on the facts of this case, but maybe for some other political reason, right? Because I said, Dr. Clark, there were 2 other in-custody deaths due to where there was physical restraint that you were the medical examiner on in 2017 and 2018, right? And I said, you classified both of those as accident, where those individuals sustained actual injuries from restraint, fractured ribs, neck injuries. They had methamphetamine in their system half as much or 25% less than Mr. Ellis. And your classification on those was methamphetamine intoxication and accident. Well, how in the world is this a homicide if those are accident? What's changed since 2018 other than the political climate, which he identifies in his PowerPoint that he's presenting to the prosecuting authority? What was his response? Well, maybe I got it wrong. I should look into those too. He wouldn't even acknowledge that it's apples to apples and you found it accident in those cases. Those cases were worse than this case, factually. Why is all of that important? Well, Dr. Clark is the linchpin to every other expert that they called. Right? Every expert had to rely on Dr. Clark's findings because they didn't do an autopsy. They didn't review anything other than what he found. And that was the basis of all of their opinion? That's crazy. How did we end up here? What else? I'm going to suggest we're done, but I'm going to get probably 15 more points about how the states failed to prove anything criminal in this case. How about their own doctor, Dr. Veal? Dr. Veal actually should have been my witness, quite frankly. Because remember, on cross-examination, when I talked to Dr. Veal, what his findings were? No act by Officer Collins caused the death. That's what I said. So your opinion, Dr. Veal, is that whatever caused Mr. Ellis's death, first off, we're not agreeing that he died from physical restraint by hypoxia. Let's assume that for sake of argument of this. Dr. Veal, your opinion is that the causation of that occurred post-restraint. Yes. That was his response, yes. And I said, and let's be clear about what we mean by post-restraint. We're talking the application of hobbles. Yes. All right, well, Dr. Veal, you've read all of the discovery related to my client's participation in contact with Mr. Ellis. Yes. So you understand factually that Officer Collins was relieved from any contact with Mr. Ellis once the hobbles were applied. Yes. You would agree, Dr. Veal, then, that no act, this is a direct question, this is what I asked him, no act of Officer Collins could have caused the death. I agree with that. Well, what do we know? Officer Collins is not an accomplice to anybody other than Officer Burbank, who was relieved at the time. State's own expert says my client's not guilty of anything because he didn't cause the death. Why is that significant? Because the state's charged my client with felony murder as it relates to assault 2, assault 3, and unlawful imprisonment. What that actually means is, one, it has to be criminal, which it's not, but let's assume for sake of argument you find that. Those acts are done, right? The assault 2 is apparently the attempted application of the LVNR. Well, that's done well before hobbles are applied, so he didn't die in the course of furtherance of that, right? The assault 3, I guess, is a taser application, which my client didn't do, but that was done well before hobbles and he's still alive, so he didn't die in the course of furtherance of that. And the unlawful imprisonment, which obviously is not unlawful, but for purposes of this argument, is done, and he didn't die in the course of furtherance of that. So he disproves both causation for count 1 and 2 as it relates to Officer Collins, and he disproves felony murder as it applies to Officer Collins. State's witness, state's expert. We're done. Dr. W. Where to start with Dr. Walglinter? Dr. W. Dr. W's entire opinion was predicated on the existence of pulseless electrical activity and normal sinus rhythm. And of course the state had to present to him before flying him up here from California to testify Lieutenant Wilson's testimony that undermined the entirety of his opinion. And so now, that didn't really matter. It doesn't change my opinion, despite the fact that he wrote a report and everything was based on that. But more significant, with respect to Dr. W, is that Dr. W is what I would say is a hired gun, right? Don't take my word for it. Julia Sherwin sends an email to Miss Eakes, says, hey, I got a list of expert witnesses that will testify that he didn't die from the heart condition, that there was excessive force, and that the officer's explanation is not valid. Dr. W's response to that is, well, I make my own opinion. Just because she said that doesn't mean I'm going to say that. Well, the funny thing is that's exactly what he said, despite having misinformation. What's even more incredible, actually laughable, is I said, well, Dr. W., Julia Sherwin attached a copy of Mr. Martinez's report that you authored with respect to Ms. Sherwin's. And you know what's weird about that? Is you cut and paste it. What was his response? Well, I'm not going to recreate the wheel. That's what he said. Why would I need to recreate the wheel? Oh, I don't know, because Mr. Martinez had 16 fractured ribs, a flailed chest, broken thyroid bone, and was beat to death. And he tries to suggest to you that's the same as this case. And so I don't need to change it. I mean, I can just change their names, which I did, and then it means the same thing. That's nonsense. He was paid to give an opinion. He flies around the country and gives the same opinion on every in-custody death case. Same with Jack Ryan and Dr. Freeman, who they didn't call. All in the same email. It's incredible. What else? I don't know. How about Lieutenant Wilson? Lieutenant Wilson, the state calls as a witness who disproves their case because he says there isn't PEA. How do I know there isn't PEA? I didn't perform CPR for 4 minutes. If there wasn't a pulse, I would have started CPR. He had a pulse. Whoops. Guess I should have shared the life pack information with everybody before that was the basis of their opinion. But once they're on the stand, that didn't matter. That doesn't change my opinion. What else does Dr. Wilson say? Or Lieutenant Wilson, sorry. Lieutenant Wilson says there is not normal sinus rhythm. The other linchpin of the state's experts. Whoops. Good information that you might have wanted to share with your experts. But most importantly, what Lieutenant Wilson says, you have his report, read it. His finding is cardiac arrest, secondary to excited delirium. State's witness disproves everything they just suggested to you. Because that's what he's seeing on scene that he sees every day, cardiac arrest. How do we know that's true? Well, you heard him talk about, I applied the BVM, bag valve mask, because he was not breathing well when I got there. If it was respiratory in nature, I applied the bag mask and I get the oxygen into his lungs. If it was not cardio related, the minute that air gets in the lungs, the heart cycles the blood and the oxygen gets to the body. He was bagging it. There was a pulse. What was happening? Well, you saw the life pack. It wasn't beating appropriately to get the oxygen to the body. He had a heart attack and died because he had a dilated heart. He had 2,400 nanograms of methamphetamine in his system, and his heart wouldn't pump the oxygenated blood to the body. That's what happened, and that's not criminal. How do we know that's true? Dr. Stankus. It was interesting because the state called a bunch of experts who just disregarded the life pack information altogether. Why is Dr. Stankus so important? Actually, let me talk first. Ms. Eakes said Dr. Stankus was not a forensic pathologist, therefore don't believe her. Well, I'm going to suggest the fact that she's not a forensic pathologist makes her more believable. Because what she does every day at Madigan ER is deal with people who are doing exactly what is happening on scene. I'm looking at the life pack. I'm determining what is happening with that heart. Is it respiratory? Is it cardiovascular? And I'm treating based on that information. So I know when I'm looking at that life pack what's happening with his heart. And she walked you through it. She walked you through the entirety of it. Look, you see these little 14 little wiggles in a row. That's the top of the heart saying beat, beat, beat. The ventricular lower portion, get that oxygenated air to the body because the heart's not working. It's saying beat, beat, beat. And then there's a beat, right? And then it goes all over the place because the heart is not working. How do we know that? She told you if this was respiratory, we would see, and it makes complete sense. If it's respiratory, you see this initial panic by the heart saying, I need oxygen, I need oxygen, I need oxygen, but there's no air. And so then what happens? It just stops, right? Imagine it. You're drowning, you don't get oxygen, your heart does just that, and then when it can't get oxygen to the body, you die. She said very clear in the life pack you would see it, right? Well, what did we see in Mr. Ellis's life pack? The exact opposite, which tells her it's cardiac related as opposed to respiratory, right? It's all over the place. Get the oxygen, get the oxygen, get the oxygen. We're talking 4 minutes before CPR of that documented. It's a heart attack. His heart failed because he's high and he has a dilated heart. How else do we know that? She talked about being diaphoretic. Remember, diaphoretic can be mistaken, as Officer Collins described, as just sweating profusely. That's not what was happening. It's 40 degrees out on a March night. Mr. Ellis isn't sweating profusely because he went for a 5-mile run. He's diaphoretic because his body is about to shut down, and her words were he was in serious trouble at that point. Right? That's consistent with what Officer Collins described. He's got sweat pouring out the top of his head on a 40-degree night because he's diaphoretic. The meth was killing his heart. He was having a heart attack, and he was going to die. That's what she said. And the state suggested that she was somehow predicting death, and therefore she's not credible. Well, she's saying he was going to die because I know those symptomology in relation to the life pack tells me that's what's happening. He was going to die. Those are the facts that have been proven. And what is not credible about that? She showed you. Unlike the state's experts, she walked you through how she got to her conclusion. Asa Lewis. What's interesting is the state suggested it in their PowerPoint that Asa Lewis somehow undermines our theory because he said, well, we see people driving around with 2,400 nanograms of methamphetamine in their system when they're arrested for DUI. Well, that's kind of what he said, right? But remember, Mr. Fricky put up the rest of the context of the questioning relative to what Ms. Eakes was arguing on her closing. I'm going to suggest the same thing applies to Mr. Lewis. Because Asa Lewis said, yeah, I see that in people who are using constantly, right? They use meth on a daily basis. They can function at that level because they have tolerance. That's the evidence, right? If you have tolerance, yes, you can function. That makes perfect sense, right? We get that. But that's not the purpose of Asa Lewis's testimony. That's not why we called him. We called him because the state presented evidence to you in their case in chief that Mr. Ellis hadn't used methamphetamine since December, right? In fact, he was in treatment. He was in counseling. He was living in a sober house where they were testing for methamphetamine. And he hadn't used methamphetamine since December, I think, 26th. Check your notes. 16th or 26th. Well, that's more than 70 days before March 3rd, which means Mr. Ellis hadn't used meth in over 2 months. And what did Asa Lewis say about your tolerance if you don't use the drug for 2 to 3 months? You lose it. And if you redose to what you used to use when you were using daily, it's lethal. And lo and behold, that just happens to be consistent with Dr. Stankus, with Lieutenant Wilson, the observations of the officers, and actually, quite frankly, Dr. Clark, right? That's why Asa Lewis is significant. And he discredits the state's entire theory of the case. Let's talk about Jack Ryan versus Chris Nielsen. First off, Jack Ryan's part of the dream team, right? The hired guns who's going to come in and say whatever you ask him to say. Flies around the country to do this. Chris Nielsen's a sergeant in Kent who the state hires, right? Mystique said, well, Jack Ryan's never testified against police before. Well, that's kind of true because he only does civil. This is his first criminal case, right? So in civil cases, he's testifying about money and damages and that sort of stuff. This is the first time he's been hired as a criminal expert. Well, let's compare and contrast those two, and you decide who you think's more credible between the two. Jack Ryan took still photographs at a rate of 1/30th of a second to tell you this was excessive force, right? He surrendered because in a 1/30th second clip of a video, he has his hands up. Well, watch the video. That's not what he's doing. He's not surrendering. He says if he's surrendering, you got to cease all force. Well, that makes zero sense because if that's true, how do you ever detain somebody? What Chris Nielsen says is, no, you have to use one step above the force because otherwise you're just sitting there slapping each other in the face and nothing gets done, right? Officers have to use one step above to restrain and control, which is exactly what Officer Collins and Burbank did. Jack Ryan suggested to you that this was an objective standard only. Remember the hypotheticals. Well, if somebody pulls out something and the officer shoots them and they later determine it's a toaster, right? That was the hypothetical. Are they liable? And he said, yes. That's not the law. We know that's not the law. You have the law. Right? That was absurd. In fact, I think the court said that's just wrong. You're wrong. Because he's wrong. Nielsen is correct. It's an objective standard looking through the subjective experience and what's happening through the officer on scene. And that makes perfect sense, right? What else? Jack Ryan says the appropriate use of force once they had the handcuffs on was just simply roll Mr. Ellis onto his side and just hold his legs there. Well, I mean, that's crazy, right? If he doesn't want to be held in that position, you're just going to hold his legs there? No. And you know what happened. He fought the entire time. You had officers from 4 different jurisdictions confirm it. Chris Nielsen. I reviewed the entirety of the video. He walked you through the video. Officer Collins did it exactly right. In fact, he was very precise about the grappling techniques he was using to try to disarm and disable Mr. Ellis safely. Once he had Mr. Ellis's back, Officer Collins wraps a leg around the hips to control the hips. That's what you want to do. Officer Collins tried to get him off onto the side and get restraints on. That's what you want to do. In fact, I showed him 21, Exhibit 21, which was Miss McDowell's second video, in which you can see and hear very plainly what the officers are doing. Mr. Ellis is facing the intersection, just like my client said. He's resisting. My client's behind him. He says 4 times, put your hands behind your back. You're going to get it again. Put your hands behind your back. He's not striking, punching, kicking. He's using appropriate force, and he's doing exactly what he should have done in that situation. Ask yourselves, how did they get into that location? If my client is on top 10 seconds before delivering elbows, it happened exactly like Officer Collins said. He comes up through them. They end up in that location. And now that Officer Collins has his back, he can employ all of those techniques to restrain him. And recall, Mystique said, why is he punching him? He's not fighting. Nielsen told you exactly what Officer Collins told you. The reason I'm delivering those strikes is because he was assaultive leading up to that. And once I gained a superiority position, if I deliver those strikes, I expect somebody who's not fighting to do one of two things. To cover up like this, and I can gain access to their hands, or they roll on their back to get away from it. And once he's on his back, I can restrain him, and no more force is necessary. It's exactly what Officer Collins was trying to do. That's what he's trained to do, and that's what he did. And Officer Nielsen told you it was textbook. What else? The video evidence. Miss Eakes suggested to you yesterday that you must convict these guys because the video evidence shows the entire incident and it didn't happen like they said. Well, that's not true. Factually, that's inaccurate. It's 50 seconds of the struggle between these individuals. Just so happens that my client describes on March 9th what he's doing and why before a video ever comes to light confirming what he said is true. So if you believe the state, you're going to have to somehow make the mental leap that Officer Collins lied about what happened before the video started and what happened after the video started and told the truth about what was on the video 3 months before he knew there was a video. Because that's the only way it makes sense. The video evidence actually supports exactly what Officer Collins and Burbank described. Does it document the initial struggle, the initial throwing, the initial tackling, the up and down? No, because that's not when Miss McDowell sees it. She sees it when she realizes the light is green and they're not going, and she backs up and sees it and starts recording. Another reason to doubt. Now remember, the state has to prove beyond a reasonable. These are all things that show what they're suggesting to you did not occur. How about this? 2,400 nanograms per milliliter of methamphetamine, fatal dose, and an enlarged heart. Both of which Dr. Clark said, absent his other opinions, would have been the cause of death, right? Those are just the facts. If that caused the death, there's no criminal liability. And they can't say it didn't. Excusable. And actually, the 2,400 nanograms and the enlarged heart gets back, I just discussed it, but go look at instruction 25. If those are things that the defendant, Mr. Ellis did that caused death, those are intervening causes. So even if you think Officer Collins' conduct somehow caused the death despite the evidence not showing that, that's what we call a superseding cause. All right, excusable. Excusable. You have instruction number 33 that talks about excusable. Not only does the state have to prove the elements of the two convict instructions beyond a reasonable doubt, look at instruction 33. They also have the burden to disprove the acts are excusable beyond a reasonable doubt. Meaning they have to disprove this. Well, what does instruction 33 say? Homicide, which is either murder or manslaughter, is excusable when committed by accident or misfortune in doing any lawful act by lawful means. Let's stop there for a second. So if they have the probable cause to arrest Mr. Ellis, they restrain Mr. Ellis, and he dies as a misfortune of these other circumstances during the course of that, it's not a crime. And the state has to disprove that beyond a reasonable doubt. Have to disprove it beyond a reasonable doubt. It goes on to say without criminal negligence or, right? So I think the state was going to suggest to you that some of their acts were negligent, therefore they've disproved this. But that's disjunctive, folks. Or means they got to disprove this too, that it was without any unlawful intent. They had to prove that there was unlawful intent. Disprove, right? Officer Collins and Burbank intended to harm him criminally to disprove this. And there's no evidence of that. And the state has the burden of proving the absence of this beyond a reasonable doubt. Didn't do it. How about lawful? Not only does the state have to prove the elements, they also have to prove the conduct was not lawful as it relates to the unlawful imprisonment and or the assaultive conduct. Well, you have instructions about what lawful is, and that the state has to disprove beyond a reasonable doubt in that regard too. So it's lawful when necessarily used by a peace officer in the performance of their legal duties, right? So if I'm a cop and I'm doing what I'm supposed to do and I lawfully arrest somebody because I have probable cause and it was necessary to restrain him, it's not a crime. And the state has to disprove that beyond a reasonable doubt. In fact, instruction 29, if after notice of intention to arrest a subject, I'm going to submit to you when they're trying to restrain Mr. Ellis, he's given notice of intent to arrest him, a peace officer may use all necessary means to effect the arrest. Take that in conjunction with the instructions I told you about yesterday about if you have probable cause to arrest, and if they're resisting, you get to use all necessary means to restrain him. That's what happened here. It's lawful. And the state has to disprove that beyond a reasonable doubt. And they didn't. Again, we're done. Ms. Eakes urged you to use your common sense. I'm going to urge you to use your common sense as well. Because your common sense tells you it did not happen how Ms. McDowell, Cowden, and Lowry suggested, or how the state has suggested in this case. Nothing about that fact pattern or theory makes any sense. If it did, why are they sitting at the stop bar at the red light when this goes down? That would make zero sense for them to jump out of their vehicle and attack someone walking down the street. Because that's not what happened. Common sense, why in the world would they do that? You not present any evidence as to why they would do that. These two officers just decided they're going to attack somebody on March 3rd for no reason. If that were true, why did they not inflict other injury to Mr. Ellis? Mr. Ellis had superficial injuries, right? He had some road rash on his face because they're trying to restrain him and his head's against the concrete. He's got road rash on his knees and hands because he's resisting on the cement. And he's got a couple hematomas swelling around his eyes where Officer Collins delivered some strikes. No broken bones. No injury consistent with them attacking somebody in the manner the state suggests. In fact, if that were true, what you probably would have seen is on Exhibit 21 where my client is saying, put your hands behind your back, put your hands behind your back. You would have seen my client punching him because he had him, striking him because he had him in a position where he could have done that if that's what his intent was. And there's just no evidence of that. So I invite you to use your common sense. The cause of death. Go back to instruction 8. They are not accomplices. The only accomplices in this case would necessarily be Officer Burbank and Collins, right? Well, the state has... Oh, I'm sorry, Judge.
It feels like you've got at least another 15 minutes.
Maybe 10, Judge. I'm almost
Okay.
done.
So I'm
I can
thinking
stop. I can stop.
This might be an appropriate break in
Okay.
this spot. So, ladies and gentlemen, let's have our normal 15-minute recess. Please do not discuss the case among yourselves with anyone else. So, Ms. Eeks, is there any issue about the PowerPoint?
Well, in the last slide, the state believes is of concern that it doesn't, it's not accurate. Statement of law is that the new one hand I wrote on, it's the only copy I have.
Yeah.
It's only related to burden of proof.
You don't like it, Judge?
Just wondering how many synonyms for not guilty you could find.
Why?
Limited only by your imagination. Okay, so the idea of guilt highly likely, you say, is not accurate, but isn't that the burden of clear and convincing evidence?
Feel highly likely.
Mm-hmm.
Here, convincing.
Highly probable, that's the way I think it's, whatever. So what's inaccurate technically about this?
Your Honor, I think that the entire, the section below, as the court noted, in terms of, what is not guilty, but also, highly likely, is that what it says, I think?
Yeah.
It is not necessarily different from beyond reasonable doubt. So, I just think that, you're injecting into what the instructions say about what exactly reasonable doubt is to try to suggest it's something even higher than that. So that's just a concern the state has.
Well, most of these are, of course, just almost silly in terms of not guilty. Proven not guilty, highly unlikely, less than likely, probably not. I got another 6 or 7 to go. Then I finally get to possibly guilty. Probably guilty, guilt likely. I don't know the difference between probably guilty and guilt likely. Isn't that the same thing? Then I got guilt highly likely. There is, of course, some cases in which you have to prove not beyond a reasonable doubt, but more than probable. And the standard of proof in those cases where we see, for instance, I think they're in, I think the most common place we see them is in when we're going to try to civilly commit somebody, is essentially that it's highly probable, not necessarily guilt, because it's not a criminal proceeding, but that it's highly probable that the state or the petitioners, if they're the doctors at Western State Hospital, for instance, it's highly probable that the person is incompetent and meets the threshold for having them civilly committed, which is different beyond guilt beyond a reasonable doubt. So I don't know that that's actually inaccurate. I don't like this particular slide if it'll make you feel a difference. But what can I say?
I would just note that the standards are, it's one thing to put on there preponderance of the evidence, clear and convincing, which obviously the standards under the law.
Clear and convincing.
Which I think the court is saying is guilt is highly likely, could be close to that, but that's actually, not the same as clear and convincing, as the court just noted. So.
Well, highly probable is what clear and convincing means.
Highly probable, right, but not guilt highly likely.
Well, probable and likely are synonymous. So
I'm sorry, what were synonymous?
guilt, likely and probable are synonymous. I don't know. You can point out, which we always point out, which is their statements of the law are not the law. It's what they say in my instructions. So, but anyway, he can use I don't like it particularly, but that slide he can use if he wants to. Okay, you ready for the jury? All right, let's have the jury.
Thank you, Judge. Probably a poorly worded bullet point. What I'm suggesting there is that the cause of death you heard during the state's closing post-restraint was referenced in the terms of they, right? They caused the death. They didn't take the I can't breathe seriously. They did those things. That's not the test. It's whether Officer Collins' conduct caused the death. So the classification of they is not appropriate. And I'm going to suggest that the term they is used because they don't know. The state doesn't know what caused the death. And so they're characterizing this as a indictment against everybody on scene at the time who just disregarded Mr. Ellis and let him die. Well, that's not what the charges are. And that's not the standard. In fact, they've charged my client with intentional acts that caused the death. They've charged my client with reckless acts that caused the death. They've asked for a lesser included of negligent acts that caused the death. Well, which is it? Right? They don't know what it is. They're going to throw it all up here and let you folks figure it out, right? Find one of these, because we don't know which it is. Because it's none of them. It's none of them. And it's not a they standard. My client is not an accomplice to anybody potentially other than Officer Burbank. The instruction tells you that. So that's incorrect. That is not the law. Finally, Matthew Collins. Matthew Collins, highly decorated officer, the gold standard, quite frankly. You heard it from everybody who testified. Officer Collins, who's received commendation after commendation about de-escalation. No use of force violations. Received the Medal of Merit. Good question. I do. Thank you. That's okay. Nielsen says, textbook, this is how you do it. He did everything correctly. He trains tactics at Tacoma Police Department because he does it correctly. That's how you're supposed to do it. You saw him testify. You saw exactly what you want an officer to do in response to a stressful situation. You saw how he handled Miss Eakes. When she got more aggressive, he called her ma'am. Yes, ma'am. No, ma'am. No, Miss Eakes. To de-escalate that. That's who he is. You haven't heard a single piece of evidence otherwise. It's exactly what he did on March 3rd of 2020. Put your hands behind your back. Put your hands behind your back. Stop resisting. Because that was the appropriate force to de-escalate Mr. Ellis's resistance. Again, he provided his statement 3 months before he knew anything would substantiate it. What he told you on direct examination was, I assumed the entirety of this event would be caught on video because it happened in a neighborhood with houses all around, cars driving by, people around. Too bad it wasn't. Because if it was, you'd see it happened exactly like he said it happened. The state doesn't have to prove motive. It's not an element. But you have to ask yourself, why in the world would Matthew Collins risk everything, just had a baby, why would he randomly attack some guy walking down the street? Why would he risk everything? Why would he do everything counter to who you know he is, as the state suggested? Because that's what you have to find. That's what you have to believe, unsupported by a single piece of evidence. How about this? How he just happened to pick the one victim who had 2,400 nanograms of methamphetamine, a dilated heart, and fights police. What are the odds of that? I'm sorry. And fights police. Right? We know 6 months earlier what Mr. Ellis did. So what a coincidence that on March 3rd of 2020, Matthew Collins decides to throw it all away, attack some random guy who just happens to have a history of doing this, who just happens to be high on methamphetamine with a fatal dose, who just happens to have a pre-existing heart condition. What are the odds of that? Because that's what you'd have to find. How did he know, as he described on March 9th, that Mr. Ellis was even high on methamphetamine? Because we know the toxicology report didn't come back until after, just before Dr. Clark authored his autopsy report on 19 May of 2020. Right? He described on March 9th Mr. Ellis being diaphoretic. How could he know that if it didn't happen just like he said? It's impossible. The state, in their closing, said, I can't breathe, I can't breathe, I can't breathe, I can't breathe, I can't breathe. No question, Mr. Ellis said he couldn't breathe. The question is, how does that make this criminal? Right? Because it doesn't. Mr. Ellis says he can't breathe. Every officer, including Mr. Ryan, Mr. Nielsen, Messiah Ford, anybody who testified in this case, said the same thing. They have to restrain Mr. Ellis. They have to. They have to control Mr. Ellis. And they have to make it safe in order to seek aid. So if Mr. Ellis said, I can't breathe 100 times, and my client heard it 100 times, doesn't make it criminal. Because he can't do anything until he's restrained to get aid there. Right? The state wants this to be an academic discussion as opposed to a real-life situation that's happening out on the streets. They want to make my client a police officer, a doctor, a lawyer, and have that inform what he's doing in a split second with somebody who's high on meth, exhibiting signs of excited delirium, and fighting with them. That's not the real world. Right? In this context, in this court, might make sense. Not out there. Now, there was a suggestion that Matthew Collins was being dishonest with you when he testified that he didn't hear Mr. Ellis say, I can't breathe. Well, I'm going to submit to you that my client's statements, if that were true and he were just lying about that, why did he leave out things that were beneficial to him that happened during the same time frame that Mr. Ellis is saying, I can't breathe? Because he didn't hear those things. He's fighting this individual, trying to restrain this individual, and there's auditory exclusion. I mean, you heard the state's own experts acknowledge that that exists. You heard Mr. Nielsen say that exists because he's fighting in the middle of the street. What do I mean by that? Well, if he were just lying and saying I didn't hear that because it benefits him, why did he leave out things that benefit him, right? Meaning, try it again, right? If he could hear and was paying attention and focused on what was coming out of Mr. Ellis's mouth, he certainly would have said on March 9th, as we were trying to restrain him and tasing him, Mr. Ellis kept saying, try it again. But he didn't. Because he's not focused on what's happening and what's being said. He's trying to detain Mr. Ellis. Right? He would have said, I told him 4 times to put his hands behind his back. And he wouldn't do that. Didn't say that either. He would have said, I heard Sarah McDowell screaming. Didn't hear that either. Because he's not focused on it. He's trying to control the situation as he's trained to prevent the escalation of force. And the state suggested, well, he talked to Chad Hayes when he walks out, right? That's their answer to that. Well, he told you, I'm holding the leg, holding on for dear life. I look over and he's right there and he's talking to us, so I see him and he says something and there was some interchange, right? That's his explanation for that. That makes sense. And they have handcuffs on him at that point in time, right? At that point, Mr. Ellis is cuffed and he's holding on to the leg, waiting for the units that he hears coming, the sirens coming to get there. And so the situation has de-escalated to an extent that he's now more aware of what's happening around him. And that makes perfect sense. But the state wants to say that's evidence that Mr. Collins, Officer Collins, is lying to you. I'm going to submit that's not the case, and you can decide if that's supported. It's clear, it should be clear, based on all of these reasons to doubt and what you sat through for 3 months. The state did not disprove this was lawful, beyond a reasonable doubt. The state did not disprove that this was excusable, beyond a reasonable doubt. The state did not prove that my client committed a felony that wasn't justified. The state did not prove that anything my client did caused the death. And those are what they have to prove and disprove beyond a reasonable doubt. Mr. Arbins, I think in his opening, maybe during jury selection, quoted Thomas Jefferson about this process. Right? He said, trial by jury is the greatest anchor ever imagined by which the government can be held to the principles of the Constitution. That's what this is about. Hold them to those principles. Because they didn't come close to proving it. Find Matthew Collins not guilty because the state didn't prove or disprove. But also find him guilty because he is not guilty because he is not guilty. He committed no crime. He did his job. And it's tragic that Mr. Ellis died. But it's not criminal. Thank you.
Okay, Mr. Conner, do you need a moment to set up? All right, so we'll excuse the jury for a few minutes, and then we'll have them back hopefully in just a very few minutes. Ladies and gentlemen, please do not discuss the case. Okay, Mr. Conrad, ladies and gentlemen, please give your attention to the closing argument of Mr. Mark Conrad on behalf of the defendant Timothy Rankine. Mr. Conrad.
Thank you, Judge. I have about 9 minutes, but I won't be able to finish in that time period. I'm going to start with a quote. The quote is from Robert Jackson, who is the Attorney General of the United States. It's, "The prosecutor has more control over life, liberty, and reputation than any other person in America. It's an awesome power our government holds to take away life and liberty. And with that power comes great responsibility. They have an enormous amount of resources." I think my co-counsel, Ms. Bremner, in opening said that there's a dangerous thing when a prosecutor is not being forthright with the facts, turns a blind eye to facts that don't fit their narrative. And so during Ms. Eak's opening closing statement, I should say, in her closing statement, she told you her recitation of the facts, and I'm sure you all sat there and listened intently, just like I did. And what she did is similar to what her co-counsel did in opening and what they told you there. And her recitation, I think, is kind of a common theme in this case. She said that our client sat on Mr. Ellis for 10 minutes until fire arrived. And in opening statement...
Advised that the lawyer's statements, remarks, and arguments are not the evidence. They're made to help them understand the evidence and apply the law, but their statements are not evidence, and they are to decide what the evidence is based upon the testimony in the case, received in the case, the exhibits admitted. So, just as it says in the instructions, I should disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. I'll leave it to them whether or not Mr. Conrad's remarks fit the evidence.
Okay.
Go ahead.
Thank you. Ms. Eakes might be right. She said that she said that he pinned him down until fire arrived, but her co-counsel in opening said this is what they're going to prove to you, that he stayed on top of Mr. Ellis until fire arrived, which was 10 minutes after Mr. Ellis last said, "I can't breathe, sir." Now, in her closing, she did give a recitation of the facts. And, there's a word that came to mind, which the word cynical came to mind when I was listening to it, because there's many things that she left out. She never mentioned once in the 8 minutes and 30 seconds that our client was on scene that he twice placed Mr. Ellis into the recovery position, that he checked his pulse, checked him for injuries, checked him for weapons, that Officer Ford, his partner that night, was right there with him. And he was talking with Mr. Ellis, telling him to breathe, stay calm, fire's coming. And that fire was called within 1 minute of our client arriving on scene. An ambulance was called, and a couple minutes later. She never once mentioned the fact that this was a high priority call. And you all have heard testimony about this over the last couple weeks. Now, when the call came out, Officer Ford and Officer Rankin both feared the worst. And you heard testimony from our client and from Officer Rankin. Officer Rankin even became emotional as he discussed remembering what the call was. And that when they asked for updates, when dispatch asked for updates, that there was no response from Officer Collins and Officer Burbank, other than at one point Officer Burbank calling out 96 in Ainsworth, and that was it. When they arrived on scene, they saw the vehicle in the middle of the street with its ambers on, but no officers inside. And they saw the two officers struggling with an individual, which we now know is Mr. Ellis. And it stood out to them because these are two very highly experienced officers that they both admire. Officer Burbank was a training officer for both Officer Ford and Officer Rankin. And the uncontroverted testimony is from Ford and Rankin as to what transpired, that the four of them were being dragged along the concrete there as Mr. Ellis fought with them. And meanwhile, they're making commands to Mr. Ellis to stop fighting, stop resisting. Officer Ford talks about taking one of Mr. Ellis's legs and holding on to it for dear life. And Officer Rankin talks about seeing a gun magazine at that point on Mr. Rankin's back. And remember, he's being injected into this scenario. He knows that two highly experienced officers are in trouble. He now sees an individual that has a gun magazine on his back that hasn't been claimed. And this individual is continuing to fight with them in the middle of the street. At that point, Officer Burbank gets bucked off. And this isn't a scenario where an individual is stealing from a Walmart, as Mr. Ryan, I think actually Mr. Nielsen talked about. This is a dangerous and unpredictable scenario. In order to ensure that Mr. Ellis does not get up off the ground in this scenario, an individual that could be armed and dangerous, Mr. Rankin, or Officer Rankin, he takes a controlled position over him. We know that he discusses this in detail with the detectives that night, or a couple days later, I should say. And at this point, we know that other officers are arriving. We know the time frames now. You know, the officers at the time that they're discussing this are doing their best to discuss what they remember. But they didn't have the benefit of looking at CADs or dissecting this now like we do. And we know that other officers arrived fairly quickly. There was 2 sergeants on scene within a minute, and multiple agencies across 4 different departments are arriving. And once officers arrive on scene there, they assist Officer Rankin, Officer Ford, in trying to restrain Ellis by putting a hobble on him. And once that hobble goes on, as Officer Ford talked about, he immediately goes into the recovery position on his side, and a weapons frisk is being done, just like the policy and training requires. And Officer Rankin took the stand in this case, and he showed you exactly what he was doing on me, in front of you all. And he did the weapons frisk, all through his legs, checking his arms, his back. He then starts to check him for injuries. He sees the cuts on his hands. He sees the cuts on his face. He sees that he's starting to sweat profusely. He talks about the fact that he took his gloves off so that he could also render aid to him by removing the probes at that point. Officer Ford is right there with him at all times. And so he removes the probes after changing his gloves. He notices that he's very hot to touch as well. And he remains in that position with Mr. Ellis through this 8-minute and 30-second period of time until Mr. Ellis starts thrashing about again. And in that moment, he again takes a control position. He doesn't hit him. He doesn't kick him. Doesn't punch him in any way. Because he's on his side, balancing on his shoulder, he puts him back onto his stomach. And as he described, because he's hobbled, he doesn't need to put pressure on him in any way that would inhibit his ability to breathe. He's merely trying to hold him in place so he doesn't thrash around anymore. Once he stops thrashing around, he puts him right back into the recovery position. He does this as they see fire about 7 or 8 blocks away. He's modulating his force and his actions to what Mr. Ellis is doing. And Officer Ford was there next to him. He talks about speaking with Mr. Ellis throughout this time period, and that the only time he left was to go tell fire that they needed to come, that he believed it was excited delirium. And this brings up another interesting point as well. So the point is that Officer Ford has a different Rolodex of experiences, and that word's been used in this case. And we're talking about Officer Rankin. He's 14 months into being a police officer, and he's doing everything by policy in that moment. There are 13 other officers on scene, 2 sergeants. If anything that he was doing was improper, someone would have intervened and done something. Officer Ford specifically discussed that as well with us. And we're talking about an 8-minute and 30-second period of time until fire arrives on scene. And
Break. Does this work for you? Would you like to go a few more minutes?
no, that's fine.
Okay, we'll take our break at this time. Ladies and gentlemen, please do not discuss case among yourselves with anyone else, and do not permit anyone to discuss case with you or in your presence.